Hello and welcome to the podcast Law for the Lay, a new game to play. I'm your host Clarissa. I'm an Australian lawyer living in the UK and taking on the entertaining challenge with guests on this show to make sense of all the laws that apply to us here on planet Earth as we try to navigate this game we call life. Today's guest is Mattias Rättzén. I met him a year ago and we basically haven't stopped chatting since as we both have an interest in intellectual property, which is often referred to as IP law, and covers intangible creations of the human intellect, like art and inventions and other fandangle things propelling the human race into new areas. So professionally, Mattias is an IP and tech lawyer, originally from Sweden, but he's also studied in the UK with an Oxford IP diploma and in the US at Harvard Law. He now works for Legal 500 firm Taylor Wessing in London. He's published several articles and spoken at conferences on IP-related issues, including most recently cross-border patent litigation, which appears to be a growing area based on our chat. Oh, and last year he also won a Talent Award as one of Sweden's top 10 young lawyers under the age of 35. Mattias has a big interest for international relations and was previously an associate delegate for several years at WIPO, which is the World Intellectual Property Organization in Geneva, on behalf of the Swedish Ministry of Justice. I always love saying Ministry of Justice. It always sounds like something out of Harry Potter. Anyway, professionally, he's very interested in supporting innovation, entrepreneurship, and technology, which is why I thought Mattias is a perfect person to explain what a patent is and what our future inventors should know. Enjoy the episode. Mattias, thank you so much for joining us here on Law for the Lay.
Thank you very much. Thank you very much, Clarissa. It's a pleasure.
It's great to finally see you in real life as opposed to on the phone all the time.
Oh yeah, totally reciprocating.
Jumping straight in, what is something silly that you love?
Many silly things I love, but one recent silly thing I've started loving actually. I love music. Everyone does, I suppose. But one silly aspect of it I tried to do recently. I tried to make my own music, actually. I've sort of had a childhood. I've had a childhood aspiration of sorts to compose my own music. And I got bored last summer and thought, hey, actually, I'm gonna start doing it myself. And I made 45 minutes of music. Probably sounds terrible to the ears of an average person.
I'm sure it doesn't.
I've not disclosed it to anyone.
Except our audience.
It's very fun, actually. And once you do something you have never done before, and it's easy to think it's easy. It sounds easy, but it's actually very difficult. I've learned, and you get a lot of more respect and appreciation for when you listen to music every day.
Absolutely. Look, I've only mastered a D chord on a guitar, so I really am impressed that you're composing your own music generally. So is it? Can we listen to it anywhere? Are you going to release it, or is this pending?
Undisclosed until further notice, I think.
Okay, I'll be keeping a lookout. Okay, into the technical side of things, because this game of life is tricky to navigate as it is. What is a patent and why is it important?
It's a simple and complex question at the same time. But I'll try to make it as simple as possible. A patent is, it's protecting inventions. And you come across patents every day on your smartphone. There are probably thousands or tens of thousands of patents. And an invention is something which has, in the legal term, is technical effect. So it's anything which is technical in the wide sense. That's a very broad thing.
Does that have to be complex, technical?
No, it can be very simple. Indeed, there are many simple patents out there. So you would be surprised, I think, if you have come across and worked as a patent lawyer, which I've done for a number of years. You would come across some very simple patents out there. Some of them are not valid, but indeed there can be very simple ones. A patent protects something which is technical in nature, has a technical effect. And I think the idea behind patents is supposed to protect significant investments you commit to when you are coming up with your invention. The classical example is pharmaceutical companies when they make drugs. Coming up with a drug and doing the research can cost billions and billions of dollars, and it can take many years. And once you have done all that research, committed all of that money and effort into trying to come up with your invention, if someone else could just copycat that, when your finalized result, your entire investment would be lost. So the idea behind the patent system is supposed to protect these investments, your inventions. But it applies equally to any kind of invention. Again, a very simple invention, which actually took you 5 minutes to come up, gets the same level of protection as an invention which has taken 5 years to come up. So the protection is the same, it's equal, it's fair to all kinds of inventions. The idea again is you're basically coming up with something useful, something which is new, it's novel. No one else has done this. It's useful to society. It has an inventive capacity. I think that's the jets and bolts of patents, of what they are. And once you get a patent, if we go to that level, you get essentially a patent is an exclusivity. It's a monopoly. Only you can do. Only you can exercise your invention. Anyone else can only exercise your invention with your permission. So that's the value essentially of a patent.
So when it leads into like when would you need one, it's in order for business purposes, and when you want to protect your ideas for commercial reasons, or do people do it for other reasons as well?
I think there are multiple reasons why you want to get a patent. The first, the two folds, two fundamental purposes. And the first is, as I mentioned, a patent is essentially a monopoly, an exclusivity, which belongs to you as an inventor or whoever you assign your invention to. For instance, a company. So it grants an exclusivity to exercise that invention, meaning no one else can do it without your permission. So you're able to enforce your patent legally by going to court to sue other companies or other individuals practicing your invention, which you have spent time and efforts and resources in investing in. So it protects that investment, but it protects it only if you're willing to enforce it. No one else will enforce it for you. You have to do it yourself by going to court. And of course, if you have a patent, someone is probably less likely to use it because they will fear enforcement if they are using it. So it has a deterrent effect, right? If someone has a patent out there, you don't want to infringe as well someone else's patent, so you want to stay clear of that to avoid getting sued.
Prevents people stealing.
Yeah, essentially. But it also has a commercial purpose, which is very important. I think that's probably the most important purpose of a patent. Again, a patent can only be exercised by someone else with your permission. So that means you want to license your patent to other people if you want to expand a market base based on that. So you can get royalty fees for your patent if you can find a market. Someone else who is interested in actually using your invention because it's actually useful, you can ask them, hey, I have a patent, it's very good. Do you want it? Do you want to use it?
That sounds like a good idea.
Yeah, it's a way to monetize your invention, and you can do it at a small scale or a large scale, depending on what your product or market is. Can be small money or it can be very significant money depending on what it is. So that's another purpose of getting a patent. And I think there's a potential third purpose as well if we're talking about small startups or entrepreneurs. And that's to brand yourself. So it's very common for startups and entrepreneurs to get apply for patents for a purpose of boosting their brand or boosting their reputation towards investors. Investors tend to be more comfortable to invest in a company which has patents protecting the product or service. So there are multiple purposes of getting a patent, why it could be useful to small companies just as well as big companies. But I think the truth is that it's a system which is in practice most useful to larger companies with significant amounts of resources. And the reason behind that, it's a very costly system.
So it's a big process for someone who might be sitting at a barbecue and they're like, oh, I've got this brilliant idea and I think I might want to patent this. And then they realize that there's a big process that follows on from that. It's probably why we haven't seen a load of ridiculous patents out there. But is there any examples beyond, I guess, the tech world or I guess in pharmaceuticals and things like that, that might be just a patent that you stumble across on your everyday life that you can think of that might be relatable for our audience?
I have actually litigated a patent in my career which concerned toilet paper. So that's something you come across obviously in your everyday.
Oh my god! How do you patent toilet paper?
There are inventions across everything you come across. It could be how communication is flowing on your smartphone. I think probably that's a very common thing for
That's
you
more
use
relatable.
your phone every day. That's more relatable as well. And there are many patents concerning how communications are flowing in or flowing out of your smartphone. Yeah, the 4G and the 5G, all of that. That's patented.
So that's all patented.
A lot of it.
Wow. A secret indulgence of mine is there's a guy's Instagram page that has all these random patents on it. And the one that I enjoyed the most was a dog chastity belt and a human catapult machine were both attempted to be patented. And I was like, imagine being the patent attorney that received that client.
I've also read that there's supposed to be a patent of the Death Star from Star Wars.
No way.
Well,
no
that
way.
would be interesting.
It'd be certainly great to work on that one. Okay, so if I did want to invent something, how do I get a patent?
Well, it's not the press of a button, if you will. It's quite a difficult process, but it has been made much more simple, thankfully, through international conventions. So there are essentially some routes to getting a patent. But first of all, the common route is you have to apply to get it. No one will get it for you. So you have to go to patent offices to apply for it. You have to make an application. You have to write the application. It can take quite some effort and cost to write the application. Normally, you would not be doing that yourself. You will need a lawyer, a patent attorney to write that application for you. It's very technical language, and the language of how you frame your patent is very, very important. And in terms of how you get the patent in patent offices, well, let's say you're just interested in the UK market. You only want to exercise your invention in the UK. Well, you go to the UK patent office and you apply for a patent there. But mostly, you want to exercise and get protection for your patents in other countries. And a patent is a national right. So it is only a UK patent only protects your invention in the UK, but because of globalized markets, how things are working across borders nowadays in our globalized world, you would usually want protection in more than just one country. So how you do that, instead of going to 180 patent offices in every country, which would be very time consuming, very exhausting. There's a centralized system that you make one international patent application, and then you just tick boxes. I want protection in these countries, these offices, and you tick them, which is much easier, of course. So you make one application, which is then spread out across any market you want. So that's essentially how you do it. Sort of there's a time-consuming limited route. You only get to one country wherever you want it. Or there's the international route where you can tick off these boxes in countries where you want your protection.
Okay, so in terms of like the financial side of things, so for example, my uncle is an inventor, and he was trying to get a patent in the US and Australia for his inventions. And he was saying the cost goes up the more that you get patents in different countries. Is that correct still today with the international patenting system, that it goes up with each country?
Indeed, the more countries you apply for, the more costly it gets. So usually, this is usually speaking, even big companies wouldn't apply for protection in 180. Big companies wouldn't apply for worldwide protection. You would usually pick off or select the markets you are most interested in. These are your major commercial markets, where you want to either commercialize your invention or enforce potentially if someone else infringes your patent. So you would be focusing on these markets, and usually that's Europe, that's the US, Australia, and perhaps China, India. Big markets usually.
Okay. And in terms of like tech and innovation, now in a more modernized system with the internet and things like that, do you think as a patent attorney it's getting easier, or do you think there's areas where you're like, oh, we could change this, and this, and it'll make it a lot easier for inventors out there?
It's definitely getting there, but I don't think we have gotten there quite yet, where it's extremely easy to apply for a patent. It's still essentially you are still hindered by its application process. There are some tools out there to make it easier for you to create a patent application using sophisticated software, and that's certainly helpful to patent attorneys who do that. There's also ways to search for other prior art, and I'm not going to go very detailed into that, but essentially, when you make a patent application, you want to see if someone else has already done it. So the patent offices, where you apply for a patent for the patent examiners, they will make some searches of what's out there to see if actually your invention is an invention. But we're also getting tools out there so you can make your own searches before you invest in applying for patents. But essentially, it's still quite a manual process in the sense that you have to apply to these patent offices to get your patent. It's a formal application. The application itself, to get it processed, I think the average time is 3 to 5 years. So it's
Wow,
actually a very lengthy
long
process.
process.
It's not the press of a button.
I didn't even realize it was that long. Is that an issue with innovation because of the lag of like if someone invented something now and then for when they got protected? Is that a problem?
Yeah, both yes and no. So some countries, a lot of countries, not all countries, they actually allow you to enforce your application as well, not just your granted patent. So before your patent is granted after these 5 years, you can enforce your patent application and claim damages once it is later granted. So it comes to the condition that of course it has to be granted eventually. So there's a way to enforce your patent application in some countries, not all countries, to get around from that. But still, it's a lengthy process, and I think it's a problem in the system actually. And I think we see some trends. One trend which is very much universal and reoccurring is that we are seeing more and more patents today, many more than we did a decade ago. So there are many millions of patents being applied for every year, and it just increases. It keeps increasing. So there's a huge backlog at patent offices to examine these patents. That is why it takes so long. One of the reasons, many years.
Wow. So a good profession for lawyers to get into is being a patent attorney. Lots of work there.
For lawyers, I think it does, of course, benefit lawyers in the sense that it gets. But I think this is how it is. It's not a perfect system because you have so many patents out there, millions of patents being applied for, being granted. Was actually the truth, and I think there have been some studies and researches, is not all of these patents are actually valid. So because there's quite a big burden on patent offices to process patent applications within a reasonable time, there's no realistic opportunity to actually search for all of the prior art which is out there, which might render your patent not new and not novel. So I think it's commonly known that the patent examination process is not perfect and that there are some flaws, and that as a result, there are patents being granted which perhaps should not have been granted. And as a result, you have a patent out there blocking the market, blocking part of the market, which perhaps should not have been granted. And what happens instead is that when you try to enforce that patent on someone else, well, usually that party might object and say that it's invalid, which inspires or triggers litigation.
And I guess that goes to the importance of getting registered.
Both yes and no. It is important to get a patent, but it does come with some caveats, I suppose. And it's not a guarantee that your patent is valid, indeed.
Okay.
That's very well worth to know.
Mm-hmm. Very important to know. If you're going to put a 5-year plan in place for your invention, you want to make sure that it's the real deal and actually worth doing.
It's not always worth doing, I think, and especially for I think smaller inventors or smaller companies. Is a patent always the best thing? That answer is not. Sometimes no. Sometimes you would want to protect whatever you're doing, either by just being the best on the market. So instead of being the only one in the market, try to be the best one and try to beat competition by either marketing or just having a really good product instead of being the only one, the monopoly on the market. That's one way, you can get on top of the market. Another way is trade secrets. You don't disclose your invention. You keep it to yourself. You keep it very secret and confidential, and that way, of course, no one else can use it because you keep it secret. There are some ways you can. A patent might not always be right for everyone, or especially smaller companies or entrepreneurs. And there are, of course, alternatives out there. And I personally think that the patent system, as it stands today, is not perfectly designed, considering the amount of patent applications we get, and considering that a lot of these patents might not actually be valid and end up being litigated instead. It's not a perfect system in how it is designed.
Yeah, and when you just said about trade secrets, it got my brain going about a lot of the TikTok and Instagram Reels pages that I follow that are about inventions, where it's like someone does something really cool in lockdown, and if you're disclosing your invention blatantly on a digital platform like that, I guess you open it up to risk that someone might, think, oh, that's a good idea, and I'll apply the same thing in my own way, and then patent that. Oh, the circus continues.
I think you should have learned that when you grew up. But if you haven't invention, keep it to yourself, and that's very much true. Essentially, you can't disclose your invention to anyone unless you basically have them sign a confidentiality agreement saying that we won't disclose it. So you should definitely not disclose your invention before you have applied for your patent. After you have applied for your patent, go ahead, because
wow. So once it's in the system.
your published patent application will, of course, disclose your invention. So once you get that into the system, keep it to yourself. It can be, of course, hard, because how do you know your invention is actually worthwhile if you can't just keep it to yourself? How do you know if it's actually worth doing? And I think how a system is developed to get that answer is you apply for a patent application, your first patent application. Let's say it could be an international patent application. It could be a national one. You make your first application, and you keep it secret before then. But once you have made your first application, you have 12 months to expand that application to other countries, or to tick more boxes, basically. And that 12-month gives you more time to sort of investigate your market and sort of see, is it actually worthwhile to expand my market? Is it a good invention? Is it worth sort of time benefit analysis, cost ratio, so to speak? So that's how the system has developed, to give you that sort of thinking time to do it. But 12 months, to be honest, it's not very long either.
I was going to say, particularly if you want to tweak things, or you're trying to get the finances behind you and all sorts of things. I have a confession, Mattias. I've got a show and tell for you. And you can tell me if this is a gig you're seeing on the planet or not. But in a charity shop, I came across the patent for a typewriter. I don't know if you can see that on camera. Our audio viewers may not be able to see that. They'll have to check out the YouTube video. But I thought it was really cool, because I was like, you can see the date that it was patented was in 1897. And for our viewers listening, or our audience, there is like an illustration of a typewriter. And I thought it was really cool when I came across it in a charity shop. However, Google's telling me that the typewriter was patented at various different times. So I thought it was a bit quirky to be like, okay, so that's what a patent looks like. And then I bought it, and I've done nothing with it since then. But I'm really glad that it was useful for this one podcast episode. So I guess the last thing I want to ask you, though, is if I was like sitting at a barbecue with you, and like we had a mate next to us, and they were like, look, I've done this invention, yada yada yada. What is something that they should be doing next in order to protect their intellectual property? So as we know, it's not like with copyright, you don't have an automatic right. They probably shouldn't even be telling us about it at the barbecue, but what would be the next step that they should do?
Exactly. We should, first thing, let's sign that. Let's
Sign that confidentiality
to someone
agreement.
else, even at a barbecue. Sign my confidentiality. Yeah, I think that's the first thing. If you feel that you have a real potential of this might be something. This might be first of all, it might be an invention, and maybe I have my own company, making it worthwhile to get a monopoly for my product or service. It's actually worth getting that exclusivity to cut off competition. Or it's actually, I can see a potential market here. I might be able to get some royalty fees. I might be able to commercialize my invention, make partnerships. If you tick those boxes, like it's actually purposeful to get a patent, the next step would be to contact a lawyer. Usually that would be a patent attorney, and the patent attorney will help consulting with you, of course, on a confidential basis, whether your patent might be indeed worthwhile and qualifying for the basic requirements to get a patent. And if so, the patent attorney will help you draft your patent application. It's something which is very difficult to do yourself, even though, again, we are getting some software out there which is making it easier to do that yourself. But the truth is that the language and how you word your patent is extremely important, because the scope of your invention is defined very carefully by words. So it's a very much a lawyer's game, so to speak. So it's very important get it right. And because you can't really cure that later on. So it's really important.
So you can't go back and edit it and things like that.
You can amend your patent application later on to make it more narrow, but you can never make it more broad. So unless you have really defined your invention properly from the beginning, you can't fix it, and your patent might not actually get through. So it's important to consult a lawyer, I think, in the initial stage. So I think that would be the next stage. If you think it's worthwhile, speak to a lawyer and see how things go, and see if it's actually worthwhile later on to go through it.
Fantastic. Well, I think that's very useful for both you and I for at a barbecue and for our audience listening today. Mattias, thank you so much for sharing your expertise and for joining me here on Law for the Lay. It's been an absolute pleasure talking to you.
The pleasure is mine. Thank you very much. And I'm looking forward to seeing you on a barbecue, Clarissa. Thank you very much.
Thanks, Mattias. Thanks for joining us here at Law for the Lay. If you enjoyed this episode, I'd love for you to swing it around your social circles and feel free to connect with me on Instagram, TikTok, and YouTube at Law for the Lay. I'm always open to your feedback and content suggestions. Please also remember this disclaimer that no Law for the Lay content should be taken as legal advice. This is simply general information intended for educative purposes. Laws change all the time, and your personal circumstances may apply differently to what is discussed. So always do your research and contact a legal professional if you need assistance. In the meantime, look after yourself, look after each other, and let's have a good time.